All right. All persons having business therein draw near to their attention, and it shall be heard that
So welcome to the Michigan Court of Appeals. We are panel 1 of the October 2022 case call session here in Detroit. My name is Brock Sorsel. Joining me today are Judges Kavanaugh and Redford. I want to thank those lawyers who are participating today. Oral argument is a key part of the appellate process. While the appellate briefs are critical, of course, views get sharpened and sometimes changed by what is said today. I'm going to go through a couple of brief instructions, though I see a lot of familiar faces, so I will keep this brief. We have read your briefs, and that be assured that we are well acquainted with your case. We've reviewed the pertinent parts of the record and law, as well as we've had legal memoranda prepared by our research attorneys and law clerks. So please do not rehash the facts or the law applicable to your case. Instead, oral argument is the time for you to highlight a key part of your appeal, to explain something that may not have been as clear as you would have liked in your brief, or to alert us to a new statute or court decision that has been issued since your brief has been filed. Most importantly, this is the opportunity to answer any questions that we may have about your case. Importantly, today's oral arguments, like all oral arguments over the last few years, are being recorded both audio and visually. And these recordings will be posted on the court's YouTube channel. Because the proceedings are recorded, please do not use any names of minors or persons involved with a personal protective order or another sensitive matter. So with that, I will call the first case for today. This is docket number 1, docket number 359502. Jędrzejczyk v. Marine, and I do apologize if I didn't get the last name on the first one correct. You do not appear to be Timothy Pinto.
I am not. I'm Zofia Peach.
Okay. You may proceed whenever you're ready.
Good morning, Your Honor, and may it please the court. My name is Zofia Peach on behalf of Ms. Jennifer Jędrzejczyk, the appellant mother from the Child Welfare Appellate Clinic at the University of Michigan Law School. At its core, this is a case about statutory interpretation and a parent's right to counsel. Under MCL 712A.17C4, a parent in a neglect case has the right to an attorney in, quote, each stage of the proceeding. And if they cannot afford one, one will be provided to them. Furthermore, under MCR 3.915B1, that right extends to, quote, any hearing. Here, the custody hearings ancillary to the neglect case were a stage of the neglect proceedings. And therefore, Ms. Jędrzejczyk, whose attorney was barred from representing her in the custody matter, was deprived of her right to counsel. At the same time, the state appointed Mr. Marine's attorney, the father, to represent him in both the custody and the neglect hearings, while again denying that same right to Ms. Jędrzejczyk. Without her attorney, Ms. Jędrzejczyk was confused by court procedures. She was unable to effectively cross-examine witnesses, present evidence, introduce witnesses, and all of that evidence would have pertained to at least 6 of the 12 custody best interest factors.
So I don't think that I disagree with your general position about how these two, what should have been distinct proceedings, were intertwined. It's hard to escape that conclusion. But with that said, so even if I agree with you on that, and I'm not speaking for my colleagues, but just for myself, you're not challenging the outcome of the child protective proceeding. There was, I believe, adjudication was at some point dismissed, or jurisdiction was sometime dismissed over the child, and neither the mother's nor the father's rights were terminated. And I'm not even sure that the father's rights were at issue, but your client's parental rights were not terminated or frankly, otherwise adversely affected in the child protective proceeding. So that would be the proceeding under which your client has a statutory or constitutional right to counsel. That would be the proceeding that we would have to order some kind of relief in terms of vacating. I can't imagine you want us to vacate what happened in the child protective proceeding.
No, Your Honor, we are strictly appealing the final custody order that was issued in this case. However, we are arguing that under the statutes, the custody hearings became a stage of the proceedings.
If that is so, when could there be simultaneous proceedings where that wouldn't be the case?
Your Honor, if this was a conventional run-of-the-mill custody case between two private parties that, for example, if a non-respondent father in this case had filed for custody prior to the neglect case being initiated, those two proceedings could be pending at the same time. However, we are not arguing for a right to counsel in that case. Today, we are asking for a
But
very...
in every case where there would be a protective services matter, where there is a right to counsel, when there is a simultaneous issue about custody or parenting time, how does the relief that you seek not suggest that there is a statutory right to counsel in all of those matters then?
In all co-pending custody matters. Here, we are asking for a pretty narrow ruling. We are asking that when a custody matter is initiated after the start of a neglect case, and that custody matter is used by the state to resolve the neglect matter. So here, the neglect case was opened, the custody matter was filed, the court and all of the parties decided that custody would be the resolution for this case. A custody matter was initiated. The neglect matter was held open for years while this custody matter was pending. Custody was changed to the father, and then the neglect case was closed out. So, sorry, Your Honor.
I think you would have a very compelling case if what had happened hypothetically was everything you just said was the exact same, except at the very end, the mother's parental rights were terminated in the child protective proceeding. If that were the case, I think I'm with you, but they weren't. And you're not asking us to overturn the child protective proceedings result, which is where the right to counsel comes into play. So you're almost using this neglect case to bootstrap the right to counsel in a custody matter, to redo the custody matter, but you don't want that custody matter to have any influence on the termination or the neglect case. I mean, I think the only sensible route, if we were to agree with you, we would have to vacate the neglect proceeding. And again, I'm not, you can't want that.
No, Your Honor.
Okay. So you seem to want us to square a circle here because you're asking us to take a proceeding where you have a statutory right to counsel to undo a proceeding to where you don't have the right to counsel, but you don't want us to affect the proceeding to which you have a right to counsel. And I'm not following how that works.
I don't believe the right to counsel in neglect proceedings under the statute relies on the outcome of the neglect case. If Ms. Jędrusek in this case had lost her neglect case, she still would have had a right to an attorney throughout all of those neglect proceedings. So I don't believe that the right to counsel turns on the outcome of the neglect case, which would also apply here. And the terms of the statute must be interpreted broadly. So a stage is merely a step in a process, and if the proceeding is just the regular progression of a lawsuit from commencement to entry of judgment. So together, the stage of the proceeding is merely the various steps taken to accomplish an act. Here, custody was one of those steps that was taken to accomplish an act. The act in this case was the neglect
stage of
case.
the proceeding, not a stage of any proceeding. So what about the word "the"? It seems like the proceeding is the protective services case.
Yes, Your Honor, I agree. The proceeding is the neglect case, and yet custody was still used as the mechanism by which that neglect case was resolved. So from the commencement to the entry of judgment, if any of those proceedings that fall within there are all stages of the proceeding under the statute. Here, custody was initiated after the commencement of the lawsuit, and it was the solution to the neglect case. Without the custody case, the neglect case would not have been closed out. That was the state's goal throughout the entire process. The judge, all of the parties were advocating for custody to be the mechanism by which the neglect case was resolved.
Unusual.
It's not, as far as I know in child welfare law, I don't believe it's unusual.
Right.
Courts
In fact, isn't it actually quite common where there is either a father who is not involved, who becomes involved, and the alternative is either termination, which of course your client doesn't want, or we can maybe avoid the termination by getting the father engaged. I mean, it is the remedy you're seeking. It's just very far-reaching consequences of a non-positive nature, it seems.
I do want to highlight the narrowness of the rule that we're advocating for here today. The rule that we're advocating for is only when custody is initiated after the start of a neglect case and when it becomes the mechanism by which neglect is resolved. This does not therefore require this court to overrule or stray from what it has held in Haller. It doesn't require, as opposing counsel has raised concerns of potentially requiring counsel in other related proceedings like eviction or welfare or anything like that. The rule we are asking for does not touch any of those issues. It is a very narrow holding.
So let me give you a hypothetical and tell me where I'm wrong. Let's assume we have an instance where there's two proceedings. One is civil, one is criminal. And the criminal defendant gives a deposition in the civil case. And in that deposition, the attorneys get into things that really touch on the criminal case. And the defendant's attorney really should have been involved in that deposition and ultimately brings an ineffective assistance of counsel claim. But let's also assume in the criminal case that it went to trial and the defendant was acquitted. And up on appeal, the argument is, well, there's ineffective assistance of counsel because defense counsel really should have been involved in that deposition. And some bad things came out of the deposition that hurts that defendant in the civil case. But again, it's only ineffective assistance of counsel, frankly, if the defendant loses at the trial court level in the criminal case. But here they were acquitted. I'm getting back to the same, this hypothetical hopefully touches on your client won essentially in the neglect case. That's the only hook you have for counsel, for the right to counsel. And I just don't see how, I'm really confused at if I agree with you that the neglect case, there should have been counsel throughout the proceedings and the custody was intertwined. You're not asking for relief in the neglect case.
No, Your Honor, but I don't believe that's required under the terms of the statute, again, because the statute's terms are effectively broad. And I do want to reiterate.
But the relief has to be, there has to be some substantive relief we can order. The relief we would order for violating the right to counsel in a neglect case would be to vacate the outcome in the neglect case and send it back for new proceedings in the neglect case. So how is that not detrimental to your position?
I think I understand the question, Your Honor. First, I don't want to stray too far for your question, but I do also want to reiterate that there was harm here. Without an attorney, Mr. Jędrusek wasn't able to present evidence or introduce witnesses that would have pertained directly to at least 6 of the 12 custody best interest factors.
But she had said she had counsel and that the counsel some 30 or 60 days later, it determines that the court or the counsel says, I wasn't actually retained or something along these lines. So your client had affirmatively represented to the court that she had her own counsel. What is a trial court to do?
Here, Your Honor, we're advocating that she had a right to counsel, and the court should have either allowed her attorney in the neglect case to also represent her in the custody case. She had an attorney that was willing to represent her in the custody case. They were well aware of the facts of the case. They had been there throughout the entire proceedings. This would not have cost the court much delay, and it would have been a pretty easy remedy. Sorry, I think I forgot the second part of your question.
I think we've thrown like 20 questions.
I think these are not single questions, single point questions. So you're doing just fine.
Thank you, Your Honor. But I do think that with an attorney in the custody matter, it could have affected the outcome of the neglect case. The neglect case still would have been closed out, but it could have potentially changed the balance between the father and the mother, and maybe the court would have reevaluated, is custody actually the appropriate? Maybe neither. I mean, Ms. Jędrusek was raising serious allegations here. She argued that she had multiple police reports of domestic violence against her, against his current girlfriend, where the child is currently living.
I think it's, at least I would not dispute that her lack of having an attorney during the custody proceedings may have impacted her, the outcome of the custody proceedings. That seems
I don't disagree
pretty straightforward. It really is this, how do you then get to the next step, which is how this affects the neglect case, in my opinion. Why don't we do this? Why don't we hear from the other side, and then you'll have plenty of time for rebuttal.
I make just one final point really
Absolutely.
quickly. Thank you. I also do want to reiterate that this entire time, the neglect case was open. At any point, the state could have amended its petition to re-seek termination of parental rights. Just because it didn't actually happen in this case doesn't mean that, based on various evidence that came out during the custody hearings or in the neglect case, the neglect proceedings were still open and the outcome could have been differently. And in many other cases, or in other cases, I'm sure the outcome could actually be different.
Sure.
Just because that wasn't here. Thank you.
Okay, thank you.
Thank you.
Good morning. I'm Julie Gilfix, and I'm representing Adam Marine, the appellee father. Just to clarify a few things that counsel said, the court was not in a position to amend any petition to refile for termination of parental rights. This was giving Ms. Jędrusek a big break, because basically she had much time to complete her parent agency treatment plan, and she failed to do so.
Ms. Gilfix, I think our time would be best spent here if you just focus in on, I mean, clearly the questions we have are pretty narrow.
Okay.
Again, I think it's hard to argue that these proceedings were not inextricably intertwined. So let's just kind of skip that issue.
Well,
but to the point of the relief sought, and how does this differ from almost any other instance where you have neglect cases and custody cases going on at the same time?
Okay, so regarding the relief sought, I agree with the court that if the court were to send it back for a new custody hearing, you would have to also vacate the decision in the neglect, because that was terminated, or not terminated, that was ended as a result of the custody. And so she was given, as I said, or I started to say, a big break because she didn't have her rights terminated. So that's very interesting to me that she would be facing termination again if she went back to the juvenile court. And I do not think she would want to do that because, as I stated in my brief, and I won't go into all the detail, but this is not a permanent thing. As you know, custody is modifiable. It's not a permanent deprivation of rights. Like in a criminal case, you have a deprivation of rights. In a child protective proceeding, once the rights are terminated, that's permanent, unless, of course, they win the appeal. But
Well, why is the
custody is not. So
why is the mother's counsel's argument wrong, if it is, to say that if the two proceedings were intertwined such that she really should have had counsel throughout everything?
okay, well,
Hold on.
sorry.
That wasn't a question yet. Why wouldn't it not be appropriate to send it back for the trial court to provide counsel during the custody proceedings, but then not require vacating the neglect outcome?
Well, I think you do. If you sent it back, as I said, you'd have to,
But
Vacate.
why?
Why do you
Why?
think that? Yeah.
because, well, as you believe they were intertwined, the reason why they dismissed the neglect case was so father would have custody and the child would be in a safe and suitable home, and she'd be secure and have that comfort being in a good place.
We only know that because of the custody proceedings. But again, if we're saying that they were intertwined such that everything kind of fell under the umbrella of the neglect case, then why shouldn't we send it back, but without vacating the outcome of the neglect case?
Well, my position is you do have to vacate the neglect
Why?
case because
And
If
if I could just add on to that, not infrequently, we will send back criminal cases on one issue, but not on others. Why couldn't we fashion such remedy in this case?
Well, because the neglect case, if you believe that this was so intertwined, and I have questions about that, I guess not so much questions, but concerns, that it was not so intertwined. There were two different
Let's
proceedings.
just assume for purposes of the
Okay.
question that they were intertwined.
Okay, so if you assume that they were intertwined, then you'd have to reopen the neglect case because the mother has not been visiting in over a year, and the court
So
would
you
need
can't
to
have
see
one
that.
without the other.
Right, the court would need to see that. What has she done? Is she doing screens? Is she using substances again? Is she in mental health treatment? All that would be looked at as part of the custody. But the problem with, and I want to say this, the problem with the custody, I know I put in my brief, there's a CPLR program that's for representation of attorneys. It's a grant program that the Third Circuit has, where they send the custody motions back to the juvenile court. The CPLR attorneys, of which I'm one of them, there aren't too many, were appointed to represent the one side and not the other side, because usually in these
I don't know
custody,
what you mean by sides.
one parent.
Okay.
Sorry. And usually in these cases, in the juvenile court, there's only one, and they're not usually contested because the other parent is not available usually. So that's why they set it up that way. They got a grant to pay attorneys to do this work. And there is no set, procedure for, now maybe they could change that, I don't know, but there's no procedure in
That's why you're saying
place
the father had representation, but the mother didn't.
He
It wasn't because.
under the program, the grant program.
Gotcha.
It wasn't because he had a constitutional right to an attorney. It was just because the court and DHS has decided that this would be, the juvenile court is more familiar with the custody because they know the family. They know what they've been through. They know what in this case, the mother had to go through in her treatment plan. And
It's a tangent, and I don't really want to open this up, but I get why, as a practical matter, sometimes or many times there's only one attorney because there's only one parent who shows up. But if two parents show up, why weren't two attorneys assigned?
Well, they have not accommodated that in their grant program. Now, maybe that could be changed. I don't know. I do know that recently they've hired the amicus
It is what it is.
clients,
I
the
don't want to
legal
get off on a
services to
tangent,
do
so.
that. But so they are going to have more attorneys doing the custody. So maybe that's in the pipeline. I don't know. But as far as that goes, that's the procedure they set up. Now, it used to be they would close a neglect case and say, just go downtown and get a custody order. And some people were unable to navigate the proceedings. They didn't have the funds and it just,
I mean,
and the
that's-
children weren't safe. So that's the whole point of this, is to keep the children in a safe place while they make sure they have a custody order so the other parent can just take them away. And then we're back to square one with the neglect case. Again, it reopens it and they have to file a new petition because the parent came back and took the child without permission. If there's no custody order, though, the mother would have had the right to do that. So that's why it's very important. And that's why they set it up this way. And I agree that it's very confusing. Even the court clerks get it mixed up. I know that when they file this appeal, they've got the correct caption, but they didn't put the correct case number, which is the domestic case number. The DZ case number should have been put on this appeal, and it's not. And even the juvenile court, they're used to doing neglect appeals. So the ironic part of this is that mother has an attorney for the appeal, but she didn't have an attorney for the custody because they were going by the neglect.
We're all
process.
familiar with the background. I think we're kind of straying from the idea of whether the mother was either constitutional or statutorily entitled to an attorney during the custody matter. So
Well, regarding that also, you had the other question, I hope I answered it. Why not send it back for custody and not vacate the neglect case? As I said, because there is some concern of the court that the mother is not an appropriate parent. So just to send it back and then suddenly does she have rights? She hasn't been visiting in a year, I'm told, supervised. So what would she do with the child? Would she just come and take the child? So that would, I think the court needs to look at it, and that's when the workers come back, because the workers, of course, are attached to the neglect case, not the custody case. But I did want to address a couple things, if I have time, regarding Ms. Jendrasik's claims that she didn't represent herself appropriately as she would have with an attorney. She was given extreme leeway in representing herself. And after reading through the transcripts, you have to see that this judge gave her an extensive amount of time. She cross-examined the father, she cross-examined the worker. Even the judge gave her some tips how to do it. And I know she said she had exhibits and she had witnesses. Well, she knew every day of the custody hearing, and there were several days because she kept getting adjournments. So why didn't she bring any witnesses? So I think that these were just claims. She wanted to delay, she wanted it.
but I mean, the argument that you're presenting right now would go to some other question other than whether she was constitutional or statutorily entitled to counsel. And that's one of two claims that she's raised on appeal. And the second claim involves whether to send it back to a different judge. So I think you're arguing a matter that's not before us.
Okay, I would also like to address that briefly regarding Judge Dingle. I've been in front of Judge Dingle many times, and he does give some personal stories in his court, and a lot of judges do that. Some judges never do
Judges
that.
telling stories, I can't believe it. Can you, Judge Kavanaugh?
Of their own personal experiences. So that's not that unusual. He gave, when you read the transcript, he gave her more than enough time, more than I think he might have even given an attorney. So he really gave her a fair chance.
I don't think we need to spend a lot of
Okay,
time on this.
I won't do that anymore. I just wanted to go over that I don't think he's biased.
Yep. The second issue, I don't think is,
Okay, you're not concerned about that. If the main concern is whether to vacate the juvenile, if this is sent back, I believe that it should be vacated, the neglect case. And since they're arguing essentially that they're together, these cases are together. So if they're together, then you have to bring them back both together if you're inclined to do that. Again, the problem is, does the court have the authority to say they're entitled
Understand
to
that.
counsel? Okay, so that's a big question too. I did have some response to the amicus brief, so if you're gonna, can I reserve my response to their brief?
No,
If you're gonna allow amicus to argue?
would, I mean,
Need to go now.
we've been focused in on two issues pretty narrowly. What more are you?
Well, that's a primary, I think you gather by the questions. That's what our concern is. And
Okay,
I mean, you can respond to the arguments raised this morning, but I don't know that we need to get into anything other than that.
okay. Well, they raised about structural error, and I just wanted to touch on that briefly.
Again,
If
this
you have
gets
any
in,
concerns or,
no, I mean, this gets into a
Okay.
question of whether there is a constitutional right. And if so, what does that mean? But I think we have a pretty good understanding of structural errors, and our Supreme Court came out with a decision over the summer that expounded upon that. So I think we're all set there.
okay.
Judge Swartzel and I were on opposite ends of one thing and his was adopted. So I now know
Oh.
exactly what structural error is.
Was that a criminal case?
Yes, it was. Yes, it
Okay.
was.
I think we're set.
So,
It's a very well written opinion, Judge. Did you?
does the court have any
I
additional?
don't think we have any
questions
additional
for me?
questions.
Okay. I
Thank
know-
you.
Thank you.
You can go ahead and put your appearance on the record, but I don't believe we have any questions. I think we've heard the position of the father, and I believe your position below was pretty consistent with what the father was arguing. So I think we're set, but please put your name on the
Joe
record.
Stewart, P 21016.
Okay, any questions?
No, I'm all
Any
set. Thank
questions?
you very
Happy
much.
In that case,
holidays.
If I may just say hi to Judge Kavanaugh, I haven't seen him in about 40 or 45 years.
Holy cow.
I'm sure he remembers you well.
I do. I'm from the juvenile court, of course.
Thank you.
Thank you.
Brief rebuttal.
Thank you, Your Honor. I just have 3 brief points. First, I would like to reiterate that Ms. Jędrusek did lose here. She lost custody. And if the court feels, and if the court agrees, then we can go back, reverse custody, and then DHS can decide whether the neglect case should be reopened. We don't believe that termination was inevitable here. Multiple accounts state that Ms. Jędrusek was making progress. The CPS caseworker at many points throughout the case said that there was no risk of substantial harm to the child. And so that decision should be left up to DHS. Secondly, I think that there is a due process violation here. Opposing counsel mentioned the CPLR program. That is the state, even though it's a funding program, that is the state providing counsel to one party in this case. The state was selectively choosing one litigant over the other to provide counsel for.
Was that an argument raised in your brief or in the mother's brief?
I believe it was in the amicus brief.
Because we're limited to we're limited to the claims raised by the mother on appeal. We can't expand the claims based on what amicus raises.
I think it underpins our,
That's fine. If it's
claim, though.
part of your argument about the
Yes.
statutory or constitutional right, but whether the CPLR program is a violation of
I
due
don't-
process is not before us.
no, correct. I'm not arguing that
I
that's an
didn't remember
unconstitutional.
seeing that.
Sorry,
Okay.
I'm not arguing that that's an unconstitutional
In
program.
the
I just
plans.
wanted to highlight that there was an imbalance of power here, which underpins a lot of the council cases and child neglect proceedings. And because the state was selectively electing to support one parent over the other in this case, which provides a heightened risk for Ms. Jędrusek, because opposing counsel mentions that Ms. Jędrusek got some leeway from the judges and she was allowed to cross-examine, but she didn't go to law school. She doesn't understand the scope of the law, the relevance of facts, the relevance of legal standards to the level that an attorney would. So it's not synonymous. It's not an equivalent remedy there. So if there is a constitutional right that was not satisfied by her ability to cross-examine opponent. If there are no further questions, I'm happy to
I am all
conclude.
set.
I don't,
So
Thank
in
you.
Well
sum-
briefed, well argued.
Thank
You're
you.
a student, is that right?
Yes. Your
What
Honor.
year are you at the
I'm a
university?
3L.
Well, you did very well for your client. You acquitted yourself quite capably. You have a very promising career ahead of you, just as our very other capable counsel do. So thank you for being here today.
Thank you very much, Your Honor.
Thank you. We appreciate it. That case is submitted. Thank you. Calling the second case for today, docket number 359394, People v. Delatorre.
Good morning to the court. Brittany Teratude on behalf of the people. I was not reserved, but I was asked to come by the clerk, so here I am.
Yeah, I found it odd, and I don't want to,
Deadline.
you missed the deadline, and that's why you didn't ask for oral argument?
It just blew my mind that I didn't ask and completely forgot, but I know that I thought we had 56 days. I am always the appellee usually, so I'm like, I have 56 days. I'll get
That's
this
fair.
brief in, and then I'm like, oh no, I'm getting that scary letter that they're gonna throw my case out.
Not they're gonna throw your case.
So given the fact, I'm sorry, do you have a question?
No,
Okay.
go ahead. Go ahead.
This is a pretty interesting question, and as far as I can tell, we don't have binding precedent in the state of Michigan. So I guess, how are we, there's a circuit, there's a federal circuit split. You have the 10th Circuit in Gillian, however you say it, that adopts Justice Kennedy's concurring opinion in the Siebert case. And then we have the 6th Circuit who went in the other direction in Ray. So what should we do here with the plurality opinion and the Kennedy's concurring opinion in Seifert under the Marx doctrine?
Well, we're in the opinion that the court should follow the LSTAT case.
But don't we only get to LSTAT if we follow Kennedy's opinion?
Correct. And we
So why do we follow Kennedy's opinion is my question.